right, kia ora koutou. Ko Jess tōku ingoa, it's lovely to have you for our part 3 of our 3-part webinar series on inbox management. I'm going to kick us off with a karakia. No, I'm going to be, oh yeah, we've already got it automatically recording. Check that out. I'm going to kick us off with a karakia, and then we're going to get into kind of setting a bit of context for today. This is the GPNZ karakia, which was gifted to GPNZ from Ngā Matapihi o Te Wairoa, which is our Hauhura Māori leads that sit across the PHO network. Kia kotahi i ngā pūkenga me ngā whakaro, hei tiaki i ngā whānau mā ngā mahi hauhura, me mahi tahi tātou mā te katoa, haumi e hui e kai ki e. So lovely to have you here to be able to host you for this 3-part series. This is the 3rd and final of the series, and it's going to wrap us up in what will be quite a good, interesting corridor if the pre-discussions are anything to go by. We are hosting this webinar in partnership with the college, so I'm going to hand over to my colleague Luke, and he'll kick us off for this session today. Kia ora, Luke.
Kia ora, Jess, and tēnā koutou katoa, everybody. I'm Luke Bradford. I'm a practicing GP and GP owner in Tauranga, where it is sunny for the first time this week, and I am medical director of the Royal College of GPs. And so we're incredibly fortunate to have such an esteemed and knowledgeable panel with us today to discuss the most eagerly awaited of the 3 webinars on the medico-legal aspects of inbox management. And we're going to look in scope about the stuff that's currently in the inboxes, where the use of a wider team and technology may fit, and the medico-legal perspectives around that, the risks and opportunities of portals, system collaboration regarding shared results, and mitigation strategies for the shared risks to practices of vicarious liability. Acknowledging that we're covering what's in the inboxes currently, not what we may wish was in there. So what's not in inbox is not in scope today. From a housekeeping point of view, we've got the presenters coming first. They're going to introduce themselves, and then we'll go to some questions which we've prepared to try and fill in the background, and then we'll have a generalised Q&A session. So if you have questions, do pop them in there. Maybe hold them back for the first half an hour to let the speaker see if they cover it automatically on themselves, and then we'll work through them as best we can. We're going to wrap this up within the next 55 minutes. I am told that the biggest challenge will be keeping the speakers on track and to task, so that is why I'm here. In the meantime, sit back and enjoy. Is Anna in yet, Jess? No, in that case, can we go to Curtis?
Not yet. She's coming. She's coming. So if Lucy can start, that would work to my flow, and we'll do Anna after her.
Fantastic. Kia ora, everybody. My name's Lucy. I'm a GP from Taranaki, and I'm also one of the medical legal advisors at the Medical Protection Society. So when you ring the MPS 0800 number, it may be me or one of my colleagues that talks to you. So I'm here today partly from my experience as a GP of 20-something years, but also from all the calls we get into our helpline at MPS about how people are managing their inboxes and the risks and the problems that come from that, including the HDC cases and issues with medical counsel. So that's my background. Look, I'm very happy to talk and answer questions.
Thank you, Lucy. I'm wary of messing with Jess's flow. Anna, can we know you've joined us? Good afternoon, mate. If you could introduce yourself.
Sure, kia ora koutou. Sorry about the stuffing around at the beginning. Ko Anna Skinner tōku ingoa. I'm Clinical Chief Advisor for Primary Care at Manatū Hauora, and have been doing some work on a shared document around results and transfer of care. I'm also a GP in Palmerston North 2 days a week.
Oh, kia ora, Anna. Curtis.
Kia ora koutou, huiria o te whakatōhira o Ngāti Parau, ko au hoki te kaihautu o te kainihira rata Aotearoa. Tēnei te mai kia tātou. I'm Curtis Walker. I'm a practicing nephrologist in Palmerston North, where Luke, we're having our first sunny day this spring. Not quite, but anyway, not as good as Tauranga. Yeah, kia ora, Anna. I recognise you, and also I think Veronique, who I saw from Waikato days. So Kia ora, thank you for the opportunity to be here. I'm not a lawyer, but I am the chair of the Medical Council, who obviously has an interest in this. And again, I'm not sure, Jess, when we're doing those little couple of slide presentations, was that now or a bit later?
Yeah, come on. You can go
Okay, might
now
as well
if
do
that
that.
works for you.
Just to sort of see a tiny little bit of context, I've got 2 slides from the Medical Council and a couple of very up-to-date figures as to the number of notifications councils received, which could relate to the area of inbox management, so really important. So anyway, I work for General Practice New Zealand. No, I don't know why that's there. Okay, kia ora. Medical Council. So fundamentally, as you will all know or should know, Medical Council is here to protect the public by promoting good medical practice, and that's a pretty broad remit, and we take it both seriously and accept that it is a broad remit and do our best across all of that. The overarching principle in this matter and in all matters that we consider standards and doctors practice in is that we've got an ethical responsibility to ensure patient safety at all times. And I'm sure none of us here disagree with that. So next and last slide, it's even shorter than a picture or whatever. I know the GPs, in fact, all of us feel a little bit like that doctor on the right there. It's probably a little bit unfair. I think DOH stands for the Department of Health in this cartoon, so it's probably a bit unfair on the ministry because their inbox is pretty big too. A couple of cascading things that I thought I'd put here. The HDC Code of Rights expects that patients will have a right to services that comply with legal, professional, ethical and relevant standards. And Medical Council standards and expectations kind of fall under that and exist in service of that, if I could put it that way. So a couple of references there. One's Cole's medical practice, which you can find on the Medical Council website. And in chapter 5, there's a specific chapter on handling of results. And I've kind of paraphrased that whole chapter, but if you order it, you're responsible for it. But there's also a bit of case law that says that if you see it, or if we see it, then we actually need to deal with it and or hand it over. So if, for example, I get a potassium call about someone's potassium that's 6.7 in the middle of the night, I didn't order it, but I have to deal with it. Right, and that's an accepted practice for which there is quite a bit of case law. Look, it is a challenge, but you know, the alternative is a result slips through the cracks because nobody did anything about it. In good medical practice, we're expected to adequately assess a patient's condition, take prompt action when needed, and that relates, and also it relates to keeping clear and accurate patient records. Moving down to a specific standard on managing patient records, we've got to have systems in place that allow us to follow up results promptly. It's pretty broad and generic, right? It does allow quite a bit of operational flexibility within that principle. We've got to be able to follow up our referrals, either people receiving referrals or making referrals to others, and inform patients and communicate those results appropriately with patients and colleagues. Finally, we do recognise that there are resource limitations and that we're all trying to do as much as we can with as little as we've got, and that many of us also have responsibilities in management and governance for these systems that we set up, and that's a really important point as well. And finally, and I think Anna was on the call for this, as have been the ministry and Te Whatu Order, we are all looking at how we can better hand over results from secondary to primary care, because frankly the issue of GP to chase is neither fair nor safe. Anyway, that's my intro. Kia ora.
No, quick, Curtis, thank you. And Nick, if you'd like to introduce yourself.
Ora koutou whānau o te whanga nui a tārai tēnei rā, ko Nick Lang tōku ingoa. Greetings to you all today. I'm joining you from Wellington, where I'm partway through a court hearing, but really delighted to join this discussion. I help lead Duncan Cottrell's medico-legal practice, and primarily my involvement comes through the health service provider arm, both in primary, secondary, tertiary care scenarios. So look, really looking forward to joining the kōrero today, sharing some of the learnings on the job, so to speak, with you from a lawyer's perspective.
Oh, thank you, Nick, and thank you for making the time on today. I understand the pressures you're under, so that's marvellous. Okay, so if we push into some questions, and I'm going to come to Lucy first, if that's okay. Lucy, what specific challenges or risks have been identified with an overloaded inbox from your guys' end?
Yeah, and look, there are lots of risks on an overloaded inbox, and I think the one that most of us expect is the missing the urgent results when you've got 5 pages of inbox results and it's the halfway through page 4 that actually that potassium is 7 sitting. So I think that is a significant risk. I know a lot of doctors actually rate their, when they're going through their inbox, they can actually look at the ones that are red first. But unfortunately, some significant results don't come out red, like an abnormal X-ray or a scan result may not come up red, but may be urgent. So I think that's a significant risk, actually not getting to that urgent result. Also, the fatigue risk when you're doing your inbox, and I know as I and a lot of GPs do, we're often doing it late at night. That risk of missing things, that we read them, but we just don't realise what we've read. Or we're looking at an X-ray result and we look at the actual thing at the bottom and we don't read the whole X-ray result and the incidental finding of the lung nodule that's in the body of the report that we haven't seen. So I think missing incidental findings or not reading thoroughly because we're tired. I think that responsibility thing that I think we're going to come on to later is, you know, it's in my inbox, it's my responsibility, but how much is it my responsibility? It's been ordered by a hospital doctor, the patient's in hospital, surely they've dealt with it. Do I have to do this? And at that kind of, when you're tired, you're probably more like to think, oh no, look, somebody else has dealt with it, file. Whereas in fact, if you've seen it, even if you didn't order it, there is some secondary responsibility, if not to act on it, to at least check that somebody has acted on it. And I think that creates quite a lot of work and also a little bit of confusion because we're often not quite sure how much that's our responsibility in different situations. Clearly, with that overloaded inbox, if you're getting people to help you with that, there's a significant risk when you've delegated to others if they make a mistake. We see that in HDC cases sometimes with locums, where locums have filed things that the GP themselves wouldn't have filed. And then when the patient has later come in, the GP just hasn't seen it because it's been filed in the inbox and they haven't gone backwards. So I think, yeah, the risk of the person you've delegated to either making a mistake or not acting on things the way that you would. And I think that delegation risk is a significant thing that we could probably talk about who you can delegate to and who's safe to do what in your inbox. Because there are some things in the inbox that are non-clinical admin that you may let an admin person do, but all that clinical stuff really needs a clinical person to be dealing with it. And so be careful who you delegate. I have to talk a little bit about vicarious liability because it's an HDC thing these days. When the HDC send out their letters when there's been an incident, there's nearly always a line there now that says, tell us about your practice protocols, tell us about your processes, tell us how you've tried to avoid this thing happening. So, you know, looking at the vicarious liability for the practices who can be criticised for poor systems or for unclear lines of responsibility. And then the other big thing that I often think is not really a legal thing, but the risk of normal not being normal. When you've delegated results to somebody else, I know there's a lot of systems where they're saying, oh, the nurse can file normals. But there are some situations where normals aren't normals. And if you actually read the HDC decisions, PSA comes up really, really, really high on the number of times that GPs get in trouble, and it's about PSA results. It's almost half of the recent decisions about GPs are about PSA. And that's because if you've had a prostatectomy, having a normal PSA that doesn't come up red on your inbox actually can be abnormal for that patient. And so filing a normal PSA is a risk. And I know for our practice, it's one of the things that no one apart from the GP themselves is allowed to file a PSA result. So CRPs are the same, you know, normal CRP, but should you be reducing the prednisone? Is it a PMR? And the MSUs is another one, you know, recurrent symptoms and they haven't got a UTI. Well, the fact that they haven't got a UTI is actually significant and you'll be looking for something else. So there are some normals that you've just got to realise should still be creating a thought about what you should be doing. So that idea that someone else can follow your normals is a little bit of a risk from our point of view. So I think, look, I've probably talked enough and I'm sure everyone else has got lots to say, but, you know, happy to take questions on any of those points.
Thank you, Lucy. And I think we will circle back round to you later around the who would be acceptable as a delegated person. And I think that, Nick, you've got some thoughts around that as well, around safety netting that needs to be in place for delegation of inbox management?
Yes, thank you, Luke, and good topic to raise. In terms of my zeroing in on that answer, I just wanted to talk about delegating, I guess, generally, then more specifically. And look, I totally acknowledge that delegating is not always easy, and in my experience requires careful attention and diligence. Taking the time, I guess, to ensure that your delegation is careful and effective and it occurs, that's a habit from my experience that can take quite a long time to develop. And where I'm delegating to a reasonably large team of lawyers, it definitely soaks up energy and effort. The other key factor that I've experienced is that it requires real trust, because you are handing something over to someone to fulfill that function for you. And so look, from a medico-legal perspective, then thinking about safety netting and in terms of delegating, well, firstly, it's probably important to think about the number of requirements that are on you, and this is the situation of you being a GP, ensuring continuity of care for your patients, and that will be a concept that you're familiar with. And I raise that, I guess, regardless of the specific legal or the ethical source of that obligation. My observation is that generally the law will hold you liable as the person who is delegating. They'll hold you liable for the actions of your delegate. And Lucy quite rightly referred to vicarious liability, which continues to be a hot topic. My recall of that derives from the Latin word for vicar, which is simply a substitute. So echoing what Curtis had outlined in Tautoko, exactly what he's noted there, the college guidance and the Cole's good medical practice standards refer to continuity of care, and have regard to those because they'll help you immensely in your task. Look, I'd also take advantage of the practice management software and tools, etc., that are available to you in your task. Look, in terms of thinking about parallels between lawyers and doctors, delegating is something very familiar for us lawyers. And if we delegate, for example, work out, it might be to deal with a complex piece of litigation or a part of arguing a matter in court. Well, look, us as the senior members in the team, we are still held responsible for their work. From a ethical and legal sense, the partner on the file carries a heavy responsibility, and just in the same way that a GP might become responsible for, say, the actions of nurse or healthcare assistant. Look, answering your question about delegation and safety nets, I was really thinking about this overnight, and I wanted to share with you, I guess, my one thought distilled from quite a number of years of legal practice now around effective delegation, and that was making space in your busy week. And I acknowledge for all of you here, to be honest, I can't probably fully comprehend how busy you are with the task of being the doctors that you are, that I know recognises and it absorbs a huge amount of energy. So from my perspective, I think, though, making room to try and think, am I able to be proactive? Is there a part of my week that I can invest time to do that? So in terms of delegating, if you're investing proactive time in your team, engaging them, training them, mentoring them, being available for questions, and really importantly, being able to be available for review so that they're feeling safe. So, look, there's a wide range of matters that I know I could speak with you about, but I think specifically around delegation, if you're documenting the scope of it, then you're spending that proactive time reviewing how it's operating. It's not a set and forget process, and it's obviously avoiding the difficult question that might come up in a cross-examination of a witness, and whether you're the lawyer asking the question or you're sitting there hearing your own doctor as witness having to answer, tell me, doctor, what specific steps did you take to audit the delegation you had in place and check it was working effectively? So my observation, the most meaningful impact you can make, take time to be proactive, and that in accordance with the guidance that you have around continuity of care, take notice of that that will be able to make the most impact on your practice. So that was really my, I guess, high-level observation. Luke, I hope that tackles where things were headed there.
Yeah, thanks, Nick. I think there's a couple of real gems in there around documentation of scope and proactively reviewing plus the availability to other team members. I think that's something that we can all look to implement. Curtis, in terms of from a council perspective and the notifications you get, are you seeing things in relation to result handling? And as a sort of corollary of that, what sort of inbox messages or do you have a view could be managed or should never be managed in an automated process?
Yeah, firstly, I just want to endorse the comments that Nick's made around delegation, and it's a bit like informed consent in that sense, and that is that, you know, we have to delegate some tasks, albeit to, say, a clinical assistant in this realm, or possibly a, you know, an automated system. And I know technology was the subject of the second webinar, because it allows more time for you thinking and less time for you having to do those tasks yourself, and therefore allows you to practice up scope with your valuable skills as general practitioners. So firstly, look, it's necessary. Delegation's an established principle in medicine, but yes, there is that point actually that our CEO's raised, because I asked her about this yesterday, Joan Simeon, and that is that you know, ultimately you as a doctor would in our system still be considered to have some liability, albeit not complete liability, for that delegation. It's the nature of delegation. But due diligence in the same way as we're due diligent over informed consent and other matters, and due diligence in the same way as we're diligent as governors or leaders of whatever organisations we're part of, I think goes a long way to showing, well, I did what I did and why I did it. And that would, you know, if you do that, you're less likely to run into trouble. So speaking of some of the notifications that have come to council, because I haven't forgotten your question, Luke, I got some data this morning. We've received just over 1,000 notifications at the Medical Council over the last 1 year, covering all manner of conduct and competence. I'll just briefly look at a few of the percentages where these may intersect with handling of inboxes. Delay in treatment, 110 notifications, or 10.5%. Inadequate, delayed or wrong diagnosis or advice, 123, or 11.7%. Inappropriate investigation, maybe that's not an inbox matter, but 48, or 4.5%. Delay or failure to provide information, and remember that's a key part of inbox management, is communicating results. 92 cases, or 8.7%. Delayed or inadequate failure to follow up, 15 cases, or 1.4%, and 32 cases of delayed referral, or 3%. Adding all of that up on the rough back of the envelope, it looks like it's probably about 40% of our notifications, give or take, relate in some way potentially to inbox management. Now that's a bit of a coarse view, but that's what I could come up with. Now, and sorry, I don't have anything in terms of trends. The risk is there that this will continue to be a problem and increase, but the opportunity is that we can significantly reduce that while providing effective and efficient patient care.
Thank you, Curtis. Yeah, I mean, 40%, certainly I'm reasonably surprised by that on the first glance, but then you actually think it through, and of course it makes perfect sense. So Anna, you're a practicing GP and you're in the ministry, and you've been doing some work with the various elements of the sector and trying to link together to battle order teams and ourselves. Can you talk us through anything that's going on around how we can help safeguard the load that goes into inboxes?
I sure can. So the work that we've been doing is, you know, I'd really talk everything that everyone else has said, because what we've been trying to do is put together a document that pulls some key principles that we can all work with, that underline all of the responsibilities everybody else has spoken about. And so I guess basically we know that transfer of care and confusion about result handling is frequently a place where there's increased harm to patients, and we've all heard about that just now. And there's been significant adverse effects of that. So our purpose with setting principles is to improve patient safety and promote equitable health outcomes. So we want to reduce ambiguity of responsibility, and also to ensure that the administrative burden is reduced, essentially. So I guess the summary of that is we want to remember at all times that the patient is at the centre of this, that is the reason we need to put these principles together, to ensure that there is not increased increased harm to patients and that patients are safe. So if we move to the first principle, the first principle is that the ordering clinician, the requester, as we've heard, is responsible either personally or delegated through defined team processes for review and actioning of the results, regardless of any subsequent transfer of care, unless it's explicitly agreed to and documented that has happened otherwise. So that's our first principle, which is essentially saying that same thing that Cole says: if you ordered it, you're responsible for it. But also recognising as we move through, so if we go to principle 2, that we may well want to share that information, and we have a cumbersome and imperfect system at the moment, and sometimes the only way to share that information is to copy another clinician into it. And when we do that, we are also very clear that that does actually, as we've talked about, distribute some responsibility, because if that result is significantly clinically abnormal, that person is obligated to ensure that the result has been followed up or to follow it up themselves. And that comes across a bit more in principle 3. But what we wanted to really clearly say is that copying in and of itself is not a transfer of care. So it cannot be expected by the requesting clinician that having someone else's name copied into that result is handing over the care to that person to follow up. And I think Curtis mentioned earlier, GP to chase is not an adequate clinical handover. The principle of an adequate clinical handover is that there is a feedback loop in which the receiving clinician has accepted care. It cannot be sort of a line at the bottom of a discharge summary. So then we move into principle 3. And we've talked about this. When remembering that patient safety is at the core of what we do, if for some reason we come across a significantly abnormal result that we have not been responsible for ordering, we need to ensure that appropriate action has been taken. Each of these principles has some more information under them in our document and some footnotes, and those do include that when this happens, you actually need to find out about the clinical context in which that test was ordered, for example, because we've already heard about normal PSAs. Normal HbA1cs are another one that are often a problem in someone with diabetes. And also sometimes there can be normal imaging that's actually abnormal for that patient as well. So it's just making sure that the clinician understands the context in which the test was ordered and when it was done. And I know that there's been some concern from clinicians both within the secondary care system and in primary care about the fact that they hold that responsibility, but we do, because the patient is at the centre here. And then if we just move on to principle 4, any sort of requirements for regular monitoring and follow-up must be agreed between the referring and receiving clinicians. And this is really covering those situations where someone might be on long-term immunosuppression and it's appropriate for that to become a general practitioner monitored thing, although the medication has been initiated in secondary care. So then there would be an agreement that going forward, those tests would be followed up by the general practitioner. Or that might be a situation, some of Curtis's renal patients that, we'll have an agreement, we're doing 3 monthly bloods and returning them to secondary care if something happens with those bloods. But that should be an agreement and with an understanding of who is taking responsibility moving forward. So those are the high level principles. And obviously underneath each of those, there is a lot more information that just really delineates that situation. We talked about in any one episode of care, only one clinician can be clinically responsible for that patient, because that is another place where things can become very complicated. For example, you might have a pregnant woman who's under the care of an LNC who develops a pneumonia. So we need to be really careful about who is managing what in that instance. So there's some other things that need to be defined. But our intention with these high-level principles is that they are a starting place for each of the regions to come together and work out within the constraints of their own IT and the resources within their communities, how can they embody these principles and have them operationalised within each region. And from where I sit within Manatū Hauora with a monitoring role, what I would want to be able to do is to come back in 6 to 18 months and say to a region, can you show me how this works in your region, that we can ensure patient safety and that there's not gaps. So that's where we're working at this stage.
And that's alongside the secondary care clinicians that you're doing that work.
Yeah, so this has all been worked through with the chief medical officers within Te Whatu Ora. So there has been agreement across all of the chief medical officers on these principles. And so, you know, basically I would see it that as consultant general practitioners and consultant SMOs within the hospital, it's our responsibility to ensure that all of our teams understand that this is the way that we manage these things. And because we know it's not usually the consultant that's writing GP to chase. So it's about a culture shift that everybody understands how we manage this transfer of care.
Thank you. And I think it's an opportune time to have a little reflection on the use of patient portals here. Now, there is and indeed Anna and I got an email this morning from an area of the country which wanted to be able to use the patient portal for patients' own health records, i.e. secondary care, tertiary care, being able to pass information on directly so the patient could see it. And whilst that is incredibly useful and we should absolutely aspire to a patient-held health record, it does pass responsibility and administrative burden to the GP, of course, who is the holder of the portal through their PMS. And so that's something that we need to work through. There's probably some useful stuff that can be done around allowing general practitioners to reach into results systems when needed, as opposed to blanket copy. And I will, however, give an interesting example of patient portals. We have full access patient portal in our surgery, including open access to notes, and thankfully my patients are incredibly forgiving of my poor typing and grammatical errors. But in terms of the results and reflecting back where Lucy was, I actually had a patient who came in and I had filed one of their PSAs at sort of 2 and thought not a lot of it, and they said, oh look, did you notice that had gone up really steeply in the last 18 months? And it was only circling back round and thinking, oh, you know, it did. So and you know, I'm holding up my own hand there that these things do happen, but it does empower patients in many ways. Of course, we can't pass responsibility over. It's us to own that result and take action for it. But it was an interesting use of the portal and benefit. As we go back, Lucy and Nick, I just want to come back through and Lucy, I want to come to you about the who, when, and what's of delegation. Do you have any thoughts there?
I have lots of thoughts there, Luke. Always have lots of thoughts. Look, I think the who is really very critical. And, you know, listening to Nick talk about the high-level principles of delegation, and absolutely agree with all those. But I think on a practical basis, when we're delegating someone to actually look at our inboxes or deal with things in our inboxes, the first thing is, are they just looking and maybe updating classifications or something like that? Or are they actually filing? I think it's a really big decision to make whether actually things are going to be filed without a GP seeing them, without the clinician who's in charge seeing them. So I think that's one thing to think about. As far as the who, if your person delegating is a registered health professional, there is an extra little layer of safety there, because that person is going to have professional responsibilities of their own. And so though you may have partial responsibility for what your locum or your practice nurse does, they have responsibilities of their own as well. And that is a little bit of safety there. I think it's one of the things we were talking about yesterday. I think it's really important to note that if you are a retired doctor and you're saying, I'll come and help out with inboxes, you need an APC to do that. You need to have, you're working within the practice of medicine, you're using your medical degree to make those decisions. You need an APC. And if you have a doctor with an APC helping with your inbox, as I very luckily have, you know, she has got some responsibility of her own, as well as my responsibility. So having a registered health professional gives you a little bit of extra safety. I think we have to be really clear that it's probably inappropriate for a non-clinically trained person to have an impact on the clinical care of the patient. So I think HCAs in general are not clinically trained, and therefore, although they may be able to do some admin stuff, you know, so if you've got an admin thing that's come back from ACC, or this patient needs an appointment, they can book the appointment or whatever it is. So there's some admin tasks that can be done, but I think clinical results and clinical letters, all those things should be dealt with by clinicians. We can probably have a bit of a debate about medical students. I think we got an opinion from one of our QCs years ago about whether or not it would be considered the practice of medicine. And obviously medical students have to have direct supervision if they're practicing medicine. And if they're doing stuff in your inbox, are they being directly supervised? So I think you've got to just think about that. And in general, what we came down to is that they can't file anything. They can maybe update classifications or write some notes or calculate the CVRAs, but not filing. The other thing to think about is when you've not only just the who but how, is actually having really good inbox management protocols for your practice about how things happen, what happens with your mammogram results, what happens with your smear results, what happens with requests for follow-ups, what happens when you get a discharge summary in, so that you've got really clear principles of how things are going to be done, and they're written down and everyone understands, and who's responsible for which part of the inbox. It's got to be all very clear. I think auditing, which Nick talked about, is really important. If you've got somebody else doing something, checking that they are doing it. When you've delegated somebody to do something for you, it's your responsibility to make sure they're properly trained to do it. So the first thing to do is make sure they're trained, and then make sure they've got the adequate resources, make sure that they've got a good protocolized system where they know what they're doing and what they're responsible for, and then auditing to make sure they're doing it properly. And look, even with all those things in place, there's still going to be some risks, but obviously there's risk in a lot of things we do, and we accept those risks because actually it's what allows us to continue to practice. So I think we have to accept some of those risks, but I think we can mitigate them by the way we delegate and who we delegate to.
Thank you. Thanks, Lucy. And we're coming up to the last of our sort of pre-thought through questions. So if people do have any questions, do think about popping them in the chat now. Nick, what risks do practices need to be looking for and mitigating against early? And I guess the swinging back round to the vicarious liability issues and the Ryan case. What do you do if one of your team is having a lack of control over their inbox?
Yes, look, one of the things, Luke, that really strikes me about this topic is I know there's a real well-being difficulty. There's an overwork difficulty. There's a pressure of practices feeling like they're needing to close their books because there's just not enough. And so, in terms of, I guess, a response to thinking about that, already talked about some of those really good safeguards, and I echo what Lucy says. The time that you're spending, I guess, testing that the systems that you've got in place, whether it's the practice management system, the software, the modifications that you've been able to make to it, that they are working, and that there's not a parallel process that is looking for workarounds given the pressures. So it's that time spent with, even whether it's internal review and audit or whether it's someone external. If it's something that you can't do yourself, can you, I guess, purchase or acquire it in from somewhere else, and to really be thinking about that from almost like a governance risk. So what I acknowledge is that as GPs, and depending on, there'll be a number of different GPs on the call, those who are employed GPs, those who are working in the practice, and those who are working on the practice, and it might be that you're having to be a combination of all of those things, and I totally recognise and understand that as a senior lawyer, having to do a mix of all of those things. But I think it's really stress testing yourselves that, are you really just focusing on getting the work done, getting through your work, or are you able to step back and spend time checking and auditing and reviewing? And that's, I think, that again, the point that I make about being proactive. It's reorienting your compass, that time is not wasted time that you should be prioritising to do late in the evening because you've had too much other work to do in the day. It's just trying to, as best you can, and I recognise there are challenges, reprioritising that. So with that focus on risk effective risk mitigation and checking. So following up where there are swelling inboxes and unread items, taking action and things that keep you up at night might be more towards the more serious items that need a good triage. So look, I'm not sure whether that specifically answers your question, Luke, but it really, from my perspective, if we are the lawyer trying to reactively persuade the HTC, the coroner, or whatever forum it is, sector services, that, hey, look, no, there were good review and audit practices in place, and here's what they were, and here's the focus, that definitely assists keeping the proactive focus if you can.
Thank you, Nick. Yeah, and it does, and I think it raises a challenging consideration for the clinicians and for the doctors out there who you're right, will be sitting there and sometimes falling into habits because of the sheer volume, and just taking that space to reflect on whether what we're doing is as effective as it could be is vital, but can seem overwhelming when faced with the burden. And a little plug there for making sure any doctors on here are filling in my work count survey. And it also swings round to the question we have in the chat about the ideal system for managing the inbox. It's quite a cheeky question because apparently you can only have 2 of the 3, which is, do you want it to be safe, quick, or cheap? I mean, I think one is non-arguable, but any thoughts?
That is your classic conundrum, although the other engineering version of that conundrum is simple, cheap, works. Pick 2. Usually applied to tech. Speaking of tech, I don't think I quite answered your question earlier, Luke, about what you could always deal with through a managed inbox and what you should never deal with. And the answer I came up to this was, I can't think of a single example of something that we could never be able to manage through this process if the process and the technology, and dare I say the artificial intelligence, the algorithms and the support structures behind it were sufficiently robust. I can't think of a single example. We did think about the empathetic phone call, but even then we know that, the studies have shown that actually a chatbot can be more empathetic than a human. I mean, perish the thought. Can be. So I couldn't think of a single example. And on the other corollary, or the other side of that, was the question was, what must always be what could never be. Oh no, one was what could never be. Another one was what should be able to always be. Well, nothing if the systems aren't in place to protect it. So that's a bit of a sort of philosophical thing. In terms of who can do this. There are administrative functions which clearly could go into either a person or an automation, and that's fine and easy. There's a lot that probably will go into AI, etc., in due course. Right now, look, and somebody's still going to carry the responsible can, right? Whether it's the GP or governor of a practice or the individual practitioner themselves, that is the foreseeable. How the technology will be regulated was dealt with in the second webinar, which is currently in New Zealand through the Therapeutics Product Bill. It's probably not the ideal way and may not be the final way, but it's the way which is currently being looked at. And I had one other final point on that. Oh, yeah, you can't delegate the practice of medicine to somebody. I think this speaks to Lucy's point. You can't delegate the practice of medicine to somebody else. So that's probably a simple way of putting that thought out there. Anyway, I'm not sure if there even was a question that I was responding to, but
I think the points were pretty on subject though, so that's helpful. Any questions popping through or thoughts, Lucy?
The only other thing I was going to talk about, because we haven't actually mentioned it, is the privacy aspect of this when we've got delegation. That the patients have a right to know who they can reasonably expect to have access to their notes. And in general, the practice team, the clinicians on the practice team, it's reasonable that the patients consider that those people will have access to their notes. So if the person that you're delegating to is part of the clinical practice team, I think most patients would accept that that's reasonable. But if we're delegating beyond that, are we seeking the consent of the patients, or should we be? So it's just one of those things to flag. And again, with the AI system, where is that information going? What's going to happen with it? So it's just something that I think when you're doing that delegation, and if it's not if you're doing it external to the practice, you know, have you got your privacy documents signed? Have they signed non-disclosure agreements and all those? You know, what have you thought about as far as privacy? And would a reasonable patient expect that that person would have access to their notes? And if they wouldn't, then have you got consent? You know, have you thought about the privacy aspects of who's actually doing that? Just another thought.
It's helpful as well, especially because I have actually managed to make a list of Ps for the management of inbox and privacy fit. So these are around protocols. The next one I'm most proud of, which is document purview for scope, proactively review of it and ensuring privacy. So I think that, you know, even if we can sometimes simplifying it like that as we think through systems are quite useful, and it comes from what everyone said.
And what about, Luke, cyber, PSY, cyber?
Oh, I like it. Yeah,
There you go.
Yeah, there we go. Because I couldn't work out how to get AI in there at all. Good. Right, now, guys, if there's no questions from the audience and you're all too busy enjoying your lunches, which is absolutely appropriate, then any closing thoughts from the panelists? I'll just give you each a minute to sum up. And if we start with Nick, because I think he's probably got to get back to
we have got quite a lot of questions there, Luke. In the
have
Q&A.
you? I can't see any of them.
So there's nothing on chat because chat's been turned off, but it's all on Q&A.
Ah, they weren't refreshing on my screen. Sorry. Right. That's why I've been doing this so badly. Right. When will the principles document be published, Anna? Have you? Oh,
so the finalised stuff has gone this week. So our next step is to ask for endorsement from various organisations, including the college and the medical council and so on, to add weight to the document, but it will be available shortly.
Brilliant. Thank you.
Thanks, Anna. So I just responded to that. Those principles all look very familiar, so I don't anticipate a problem from council's point of view. I was going to suggest that the principles are easy, right? We all agree no one should die in road crashes. Problem is people die in road crashes every day for any number of reasons. So it's how you rubber meets the road, so to speak. But no, look forward to receiving that and expeditiously getting on with it.
Yeah, fantastic. Thank you. Given what we've heard today, should all testing have follow-up with the patient, if only to fund non-charge time in the evening work, which will not be charged? So this is that's that difficult thing. Is that, you know, we should be following up. We should be checking that the patient's understanding of it. We should be checking it's all done. This is happening out of hours in unfunded work. So how do we get around it? Any thoughts?
Yeah. It's a really hard one because it's one of the things that I always think when I started as a GP, the inbox used to be on a clip at lunchtime, and it was a few paper results and a few letters from the hospital, and it literally, I could do it in half an hour. And obviously that's not a situation now, and the funding hasn't changed. We could talk to the ministry about that. The funding hasn't changed to reflect how much of our time is now spent doing this thing, the inbox issues. And the question is, getting a patient back, yes, you can then charge them. But there are lots of situations, as many of us find, that you haven't got free appointments to see these patients in, you know.
Or they can't afford to pay anyway.
Or they can't afford to pay.
And we create, I would say it's yet another plug, is that there is a piece of work going on through the college this fortnight where we are looking to properly document the distribution of work and the percentage of all of the extra components. And that will give us a really much better idea of the amount of work, all work that is not just clinical facing for general practice, because we haven't done that in this country before. We're quite excited by that.
And I think the charging, you can charge for replying to portal emails. I think it's reasonable for practices to look at what parts of their inbox which are not related to the patient consultation, so therefore don't fall within the PHO agreement. Well, they're not PHOs now, but that what parts you can charge for, because as long as the patients are aware of what the charges are before you make them, and they're reasonable charges, GPs are allowed to charge for work outside of the consultation.
Yeah. Curtis.
I'd have just 3 quick responses, 2 of them serious, 1 twee. The first 2 serious ones, don't commit fraud, obviously. The second one is if you work, you should get paid as a principle, that we should all sign up to, and if that's not currently being captured, it should be, frankly. And 3, the slightly twee one is a GP colleague who many of you will know, Stephen Lillis, who wrote that chapter in Coles, famously has said, or at least I heard it, I don't know where he got it from maybe, but if you think quality costs, try making a mistake.
Yeah.
So if it takes time to get this right, so be it, and it should be recognised. Now I know that's in an ideal world, but let's work towards it.
I just want there's a question on here which I think is really important that we voice in it, and it may be Nick or Lucy on this. Transfer of care to GP. How does this loop close medico-legally if a GP does not want to be responsible? Should the discharging clinician talk to the GP and gain the agreement?
Lucy, I know you've done a fair bit of discussion in your time on this. I guess my immediate response to this, you've just got to be really clear. If you're wanting to not make it your responsibility, you identify really clearly with yourself why, and you don't sit on it, you make that very vocal and deal with that. I mean, having regard to a number of the principles that Anna's enumerated and in what good medical practice looks like, it's a concern that if it looks like passing the buck, it smells like it might be. And so that's not at all from my perspective to trivialise the question, just to try and make really clear what your lines of responsibility are and invest the time to negotiate or change those if they're not working for you.
In terms of that, guys, so often it will say the transfer of care or the passing over of the result won't come with discussion, as we've indicated. It will come with a please do this. Where do the GP stand medico-legally on that if it doesn't then happen without an agreement? Is it tacit agreement by not actively saying no?
So basically, the way the HDC seems to handle this is that if the GP was copied the results, so the GP's seen it, and they were asked to look at it, in that situation, there is definitely at least some of the responsibility will sit with the GP. Yeah. If the GP is say, please can you review the X-ray results, but the GP never gets a copy of the X-ray results, then the HDC generally seems that they don't expect the GPs to go looking for things that they haven't been given. So that it may not be universal, but that's my experience with how it goes. If you've seen it, because of those principles, once you've seen it, you've got some responsibility anyway. And if they've asked you to deal with it and you've seen it, there is likely to be some responsibility there. If you never get to see it, if it doesn't turn up in your inbox, you've got much less responsibility, but probably not zero. But, you know, I think it's a much less. I think if you get a letter from a hospital that says, please can you, I got one recently from an endocrinology registrar who did all these blood tests and then discharged the patient and said, please can you follow them up? I didn't know what any of them were. And if I really wanted to reduce my responsibility for that, I would have written back saying, I'm afraid that I don't know what these blood tests are. I'm rejecting your transfer of care. No. In fact, I didn't, because it would have taken time to write back to the endocrinologist, so I didn't. But then when I got one of these results back that's abnormal, that I don't know what to do with, I've written back to them now saying, yeah, now what do I do with it? So I think that's the kind of practical. You can, if you're being asked to do something that you think is outside your scope of practice and not appropriate, you write back and say no. Otherwise, in the majority of situations, if it's turning up in your inbox, there is going to be some shared responsibility, and that's still based on Anna's principles.
Yeah, I think that's fair, Lucy. I mean, it goes the other way too. I mean, I'm not wanting to invite, you know, every GP colleague or every other colleague to be writing me their creatinine results, but you know, the same goes other way. Yeah, I see Anna smiling at that one. But I mean, you know, you know, it goes across professions, so into other parts of health, you know, nursing colleagues, pharmacy colleagues, etc. It certainly, you know, can and does come back the other way. So therefore, it's a collective responsibility of us all to respond, I think, the way that, you know, you've outlined, but also to behave in a way which supports each other, basically.
Absolutely. And I think there's a bird of mirror on GPs that you'll often see it from intra-hospital comments where somebody will, a specialty will have ordered a test, say prolactin, and they'll come back and they'll say, we're not sure what to make of this, we'll ask endocrinology. There's an immediate, whereas in general practice, of course, we tend to try and have some knowledge across all. Look, a couple of last things quickly, and then I'll come to you, Nick. Does the patient access to the record, or indeed instructions to patients around how to follow up, mitigate in any way clinician responsibility?
Are you answering that, Nick, or would you like me to? I can answer it if you want me to.
Look, Lucy, yes, what I wanted to say, regrettably, was ngā mihi nui. I need to return to my court hearing, but my closing words, you've already heard them from me, are be proactive. Ka kite whānau.
Thank you, Nick.
So tell me again, Luke, what was that question?
So Lucy, the question in from Martin, sorry, is does the patient access to a record or a portal mitigate in any way clinician responsibility? That's interestingly linked to a
little tiny, not very much at all. Generally, the HDC considers that the GP is the person who has knowledge of what the meaning of that result is rather than what the number is, and that even if patients have access to their results, unless it's been interpreted for them, there is only a very limited responsibility. But having said that, it does help at the HDC if there is very clear evidence that the patient was copied the results and was told to come back and then they didn't, or if they were told, please contact us if you've got any concerns. All those kind of things are really helpful and do help show appropriate practice. And they're all appropriate things to do. They're all a bit of a safety net, but it's never going to be 100%. The clinician is still going to have some responsibility there if they ordered the test and they haven't, and it wasn't acted on, even if the patient did see the result.
Thank you. But just because he is a distinguished fellow, I will read out Joe's comment before we close. If the definition of the practice of medicine applied by MPS is the filing of results, where does that leave robotic process automation? Are there no hospital specialist services where someone is delegated to file results who is not a registered health professional? I think the pragmatic need for the system is to allow, with all the caveats of training and scope, non-registered health workers to be able to be delegated to perform some of these tasks. So that's people have argued that on the basis that the workload is so high. I suspect the answer will end up coming from the automated process and the AI system. Right, guys, I am nearly on time. Any closing thoughts from you, Curtis?
No, but Joe's obviously posed a really important question that we touched on yesterday. Don't have time to answer it now. That's really, I mean, at one level, Joe, reductio ad absurdum, you could argue that a computer painting a result red is a triaging of and filing of a certain result as abnormal at one level, and of course that happens all the time now. So look, I suspect there's some nuance to this which will need to be carefully thought about by many. There we go.
Thank you, Curtis. Anna.
I think we've covered the principles well, and I completely agree with Helen's comment around how do we do closed loop confirmation, and we really need our IT to make that happen for us because it's unworkable as it stands at the moment. My other last little plug is for choosing wisely, because one of the best ways to make your inbox manageable is by asking yourself what question you're asking when you order that investigation, and that makes a massive difference to workload. Obviously that doesn't help with what secondary care sends you, but it makes quite a big difference to your own day-to-day well-being, I find. So
we choose wisely.
Oh, P.S. It's not the creatinines, Curtis. It's the blinking parathyroid hormone. Can I send you all of them?
Thank you, Anna. Lucy.
Oh yeah, look, such a big topic, isn't it? And I'm just going to say, Joe, MPS doesn't define the practice of medicine. The Medical Council does. That's not us. And look, I'm sure there will be automatic processes that have got some really good reliability, probably better reliability than us actually. So I think there is no doubt that's coming, and look, I think we're all looking forward to that. I also would very much like to agree with Anna about the fact that we need IT that supports us for closed loop and for communication between primary and secondary care. I think that at the moment it is very stilted, and there isn't a good ability to talk backwards and forwards about issues. So I think, yeah, IT getting better is my main hope, but also just thinking about things when you're delegating and having really good processes so that when and if something goes wrong, because look, things go wrong even when we're doing it ourselves, and if somebody else is doing it for us, things will go wrong. So just having some really good processes and protocols in place, making sure people are properly trained and that you're checking that things are happening as you expect them to be happening.
Thank you, Lucy. And I think reflecting back, actually, if we look at the changes over the last 10 years, they have been massive and possibly and actually probably positive in terms of our ability to communicate between jurisdictions and areas within the health service, and I can only hope and see that that improves as we go forward. So thank you, Curtis, Anna, Lucy and Nick. We've heard that don't only just look for red in the inboxes, it's often there are other serious results there. Be careful not to miss things in the results, and normal might not be normal. Continuity of care for the patient is key, and medico-legally. Take advantage of practice software when there are solutions. We may be looking at a consultant GP as we go through delegations, and we must always be available to anyone we have delegated responsibility to ensure that they can come to us and clarify clearly. Remember the 4 Ps: protocols, purview, proactive review and privacy. Ultimately, the doctor is responsible, and we need to keep that in mind. The council will get up to 40% of their notifications related to this, and so it is key. But if we can build agreed principles through the system from secondary through primary and stick to them, it will start to unload the inbox, as we'll choosing wisely. The patient portal is not a replacement for a patient-held health record, but it does have opportunities for improving it. And regarding delegation, the APC is likely, and the clinician should be a clinician and registered. There is real grey areas around the use of medical students, and it is not appropriate to use non-clinical staff for clinical analysis. There's an acknowledgement of the load that we all face from our inboxes, and that a reassurance that those in the sector in positions of governance and responsibility are taking it seriously, and we are all continuing to strive to improve it for everyone out there. The systems may be coming, but they're not quite there, and when they are, we must ensure that they are robust and that the patient is at the heart, with safety at forefront. Thank you, Jess.
Ngā mihi nui, Luke. That was a beautiful summary that you just whipped out with no notes prepared, and I love the 4P model. We might have to get that up on a slide to include in the resource pack. We will be sharing all of the resources this week, so GPNZ members, you'll be able to find that on the GPNZ portal, and then we will upload it to the GPNZ website within the next 10 working days. I'm just going to give our comms time to breathe because it's a busy time of year. The webinar is being recorded and it will be uploaded to YouTube, and you can access that via the GPNZ website. So if you've got colleagues that you want to send this way, that's where you'll find the recording. Thank you to our panelists for closing out our 3-part webinar series. It's been an absolute pleasure being able to bring together the threads of workforce, technology advancements and medical legal risk and perspectives into this series, and be able to kind of create a resource for general practice and PHOs to be able to inform and inspire their work moving forward. So as the issue evolves and as we continue to move through the sector, you're not alone. We're all together, and we'll try and support and upi as much as we can do. I'm going to close us out with karakia, and I hope you all have a beautiful afternoon. Whakamaua te kōrero, whakamaua te wānanga, whakamaua kia rangi nui e tu iho nei, whakamaua kia papatuanuku e takuto aki nei, whakatina ki te tumu o te maramatanga kia tina, tina, hui e tae ki. Ka ki te koutou.